Okay. Hello, everyone. My name is Michael Pereira. I'm an attorney here at Hirzel Law, and today we're going to be talking about all things rentals. That includes requirements, short-term rentals, rental caps, and remedies. So I'm excited to spend this time with you. And before we get into everything, if you could just make sure that you are on mute, that just prevents a lot of accidental noises from happening throughout. So with that, let's get into it. So, summary of topics. First up, we have standard rental requirements. Then we're going to talk about short-term rentals, the rental caps, and condominium association remedies. So first up, we've got rental requirements, and that involves MCL 559.212. That's part of the Michigan Condominium Act. And let's move right into a hypothetical. So we've got Lucifer, the landlord, is a co-owner in the Renters Paradise Condominium Association. The condominium bylaws are silent regarding rentals. Lucifer does not want to involve the association, and he rents his units to Party Animal Pete without a written lease. The association's board of directors want to know the identity of the tenant who is throwing all the loud parties. The association security guard loves to sing, "Don't Stop the Party," and does not seem to be much help. How can the association find the identity of the renter and put an end to the parties? So I'll let you think about that for a second. And then now let's get into the requirements of the statute. So first up, we have a co-owner, including the developer, must disclose rentals to the association at least 10 days before presenting a lease or otherwise agreeing to grant possession of a unit to potential lessees or occupants. A co-owner, including the developer, must supply the association with a copy of the exact lease for its review for its compliance with the condominium documents. A co-owner or developer shall also provide the association of co-owners with a copy of the executed lease. And if no lease is to be used, then the co-owner or developer shall supply the association with the name and address of the lessees or occupants, the rental amount, and due dates of any rental or compensation and the term of the proposed arrangement. So with that in mind, returning to Lucifer, under MCL 559.212, because he does not have a written lease, he is required to disclose Party Pete's name to the association. So if that's what you had on your notepad in front of you, then good job. You already know about the Condominium Act's requirements for renters. So that was the short and dirty about the rental requirements. And most of those, I'll go back for a second. So most of these requirements are also commonly found in condominium association governing documents. But even in the absence of those requirements in the governing documents, a condominium can still require compliance with those 4 provisions because they are part of the Condominium Act. So now we will go to short-term rentals. All right, another hypothetical question here. So we have Tranquil Acres Condominium Association was formed in 1985. The condo has 25 units on lakefront property. The condo bylaws state that units are to be used only for residential use. The bylaws do not specifically prohibit rentals. And over the past 2 years, investors purchased 5 units that are regularly listed on Airbnb. Tranquil Acres has turned into Party Acres. Can the association prohibit short-term rentals? What do we think? Yes, no?
Yes.
Yes, all right, 1 yes.
I say yes also.
All right, we got a couple. Eunice in the chat also says yes. All right, so pretty much unanimously at this point, we're going yes. Let's find out if that's true or not. So under O'Connor v. Resort Custom Builders, Inc., the Michigan Supreme Court held that use of property for 1-week timeshare intervals violated the residential use provision of the deed restrictions. So looks like we have a unanimous win for everyone who said yes. And then that kind of turns into what is a residence? And the court considered that, and although this isn't a technical definition, it is a pretty good definition for lay people to think of. And a residence is a place where someone lives, has a permanent presence as a resident, where they physically, whether they are physically there or not. Their belongings are there, they store their golf clubs, their ski equipment, their old radio, whatever they want. It is another residence for them, and it has a permanence to it and a continuity of presence. That's what makes something a residence. All right, I see a hand up from Kay Lloyd. Do you have a question?
I'll wait. It was from the first question about the 10 days. And well, actually, how do we monitor the 10 days? How do we know it's 10 days prior?
So typically in that situation, the co-owner would say, hey, I have somebody that wants to lease, and can I have the association's permission to do so? So it is a little bit on the honor system, but you can also check in on that, because if a co-owner says they want to rent and then the next day somebody's in their unit, you can tell that the 10 days wasn't complied with.
Okay, thank you.
Yeah, good question. Oh, why'd that go away? There we go. Okay, so another hypothetical, but this time there's a little twist to it. See if you can catch what it is. All right, so Tranquil Acres Condominium Association was formed in 1985, still has 25 units on lakefront property. The bylaws prohibit commercial use. The bylaws do not specifically prohibit rentals. Over the past 2 years, investors purchased 5 units that are regularly listed on Airbnb. Tranquil Acres has turned into Party Acres. Okay, so with this little twist, you might have noticed that the bylaws changed from residential use to prohibiting commercial use. So under this commercial use prohibition, can the association prohibit short-term rentals? What do we think?
Yes.
All right, we got
Yes.
1 yes,
Yes.
2 yeses. All right, we got a couple
Sure.
yeses in the chat as well. All right, so that seems to be pretty much on board with yes.
I say yes.
Let's see. Short-term rentals. Another Michigan court case, this time from the Court of Appeals. Eager v. Peasley says that holding that a rental on HomeAway.com violated the private occupancy and private dwelling restrictions and was a commercial use. So in this case, why were the covenants violated? The owner didn't live at the property and rented the property pretty much exclusively to a variety of groups, such as tourists, hunters, and business groups. The renters or the transient tenants had no right to leave their belongings on the property, and the rentals were available all year on HomeAway.com. And the court defined a commercial use according to Black's Law Dictionary, as anything used in connection with or for furtherance of a profit-making enterprise. I believe that the owners in this situation, they were charging, I believe, $150 to $250 a night, or they also had weekly rates available for, I think it was like $1,500 a week. So whether or not they seemed to be making a profit based on those prices. Okay, so short-term rentals and your bylaws. So as we discussed in the two hypothetical questions, there are common use restrictions, whether that is a residential use restriction or a commercial use restriction. So a residential use limits the use of a unit to only residential units or residential uses, whereas a commercial use prohibits commercial uses. So those two are pretty much two sides of the same coin. There can also be leasing or rental restrictions explicitly in the bylaws, such as prohibiting short-term rentals by requiring that any rental has to be above a certain time period, such as 12 months. Then there's also the opportunity to restrict against nuisances from occurring in the condominium. This would be in the case of tranquil acres turning into party acres, where tenants and renters are throwing parties and being loud and just generally creating a nuisance. That can also be a way to prohibit rentals. And lastly, we have unlawful activity restrictions. Sometimes, depending on where your condominium is, the municipality may have restrictions prohibiting short-term rentals, or at least requiring that any rentals be licensed through the municipality. And again, that just is, it's very municipality dependent. Not every municipality has those kind of restrictions. And then there's also a way that clever landlords or clever co-owners might try to rent out their units by saying that they're not renting, they're just licensing someone else to use their unit for a period of time. So we recommend that associations consider prohibiting licensing of units in addition to the standard use restrictions or rental restrictions to avoid any kind of creative arguments from co-owners who are bent on renting out their units. Okay, so now, sorry, was there a question?
Can you clarify the licensing of a unit?
Yeah, so a license would just be an agreement whereby the co-owner would say that this person has the license or they have a contractual ability to stay in the unit. And so it's essentially a rental, but they're just kind of defining it, or the term that they're applying to it is it's a license, not a rental. So it's similar to if you have software installed on your computer. Typically, those are, you have a license to use the software. You don't necessarily own that software. And so in that vein, you could see yourself as renting the software, or you more accurately probably have a license to use it. So that's essentially what it is. It's people who try to label the rental as something other than just a rental.
Yeah, Michael,
Yes.
I have a question. I'm sorry, it's regarding the first issue with the 10-day notice on a lease. What is
Yeah.
what is the association's remedy if that lease isn't presented to the association 10 days prior?
I'm glad you asked, and the association's remedies are going to be our last topic that we discussed. So I don't want to spoil anyone's fun by giving you the answer right now.
Okay.
But if you still have that, if I haven't answered that question at that point, feel free to bring that back up and we can talk about it then.
All right, thanks.
I'm confused
sorry.
over the difference between licensing and renting. The analogy you used with software is I'm in essence licensing an intellectual property,
Mhm.
whereas a condominium is not an intellectual property. Are there any court cases that make that sort of distinction, or is that one of the a film at 11 because it's going to have to work its way through the system at some point in time?
To my knowledge, the issue of licensing in terms of rentals is more or has been brought up in other states and other jurisdictions. I don't believe that there is any case law in Michigan at this point with the licensing versus rental argument. The fact that we recommend the prohibiting licensing in short-term rental cases kind of means that we have seen this issue before or it has been brought up. And so I anticipate that it will not be long until we have a Michigan Court of Appeals case that discusses licensing. But at this point, that doesn't exist, again, to my knowledge. So turning to the licensing in terms of intellectual property, it might not be the best analogy for intellectual property versus real property issues, but I think that the overall concern about prohibiting licensing is just to cut off and avoid creative arguments that someone might raise before they have the opportunity to raise it.
Okay, can I ask a follow-up question? Because
Sure.
to your point, Black's Law Dictionary does define both of those. So should we then, because we're coming up on getting ready to revise, update our bylaws, and that is really creative language that they're starting to use. So we really need to be careful, to your point, and go in and express it as the invitation and permission so that we completely eliminate that as an option.
Mm-hmm.
Okay. Wow. It's getting to be pretty creative. Thank you.
You're welcome. So if there's no more questions about short-term rentals at this point, and if you do have any questions, you can also hold them until the end when I'll just take anyone's questions about the presentation. So if you haven't thought of anything, hold on to it until the end. I'll get to you, I promise. All right, so let's talk about rental caps for a quick minute. So rental caps in the context of the FHA, the Fair Housing Act, no more than 50% of units can be rented in existing condominiums to qualify for FHA certification. And FHA certification could be something that an association would like to pursue because it increases the potential pool of purchasers that may be able to buy a unit by qualifying for an FHA insured mortgage. So FHA insured loans, they're a type of federal assistance that has historically increased housing access. And so, like I said, 50% of rentals have to be, or 50% of units have to be co-owner occupied, and up to 65% of units can be rentals in an existing condominium. If the condominium is more than 12 months old, the governing documents have at least a 20% reserve requirement, which is different from most Michigan condominium bylaws only require 10%. No more than 10% of total units can be in arrears, and 3 years of acceptable financial documents must be provided. And then
I was a little
Sorry.
confused on the red where it says 50% in existing condominiums, but then 65% if it's more than 12 months old. So the 50% figure covers only literally brand new condominium developments, and after a year old, it can go up to 65?
I believe that's true, but the 65% rental, I guess, rental cap, for lack of a better word, also has those 3 other requirements in there as well. Whereas the 50% threshold does not have those 3 requirements. Okay, so then there's also requirements for governing documents, such as leases must be in writing and subject to the condominium documents. The association may request a copy of the sublease or the rental agreement. The association may request the names of all tenants, including the tenant's family members who will occupy the unit. The initial term of a lease cannot be less than 30 days. The association may establish a max lease term, and rental caps are permissible, and the association may not require that a prospective tenant be approved by the board of directors. Okay, so in addition to FHA issues, there's also practical considerations for implementing a rental cap. We normally recommend between 10 to 20%, no more than 10 to 20% of units may be rented. But practically speaking, the rental cap should be less than 1/3 of all units, because for voting issues or document amendments, those voting issues require a 2/3 co-owner approval under the Michigan Condominium Act, and having co-owners occupy the unit and be involved in the association typically increases their participation in such voting activities, whereas if they are just renting their unit full-time to someone that they don't know, they just might not be terribly involved and might not participate in votes. And there's also the 2/3 mortgagee approval under the Condominium Act. So to implement a rental cap does affect the leasing restrictions, which under MCL 559.190A does require the mortgagee approval. And if a rental cap is being added through an amendment and the condominium is, or the amendment occurs before the transitional control date or during the development and sales period of the condominium, the developer also has to approve the amendment. And an amendment can't affect the rights of any lessors or lessees under a written lease, otherwise in compliance with the Condominium Act, and is executed before the effective date of the amendment, which just means that if there is a current rental happening as of the date of the amendment, when the amendment is effective, that lease must be honored. So for property rights, that's just the reason that that's in there. And then there's also ways to grandfather in existing leases, such as an explicit grandfather clause that allows a co-owner to continue renting until the existing lease expires, or the co-owner can continue to rent until they sell their unit or stop renting or offering their unit for rent. So those are two alternative grandfather clause options in the event that an association would like to amend their documents to include either a rental cap or just to change their rental requirements.
Question.
Yeah.
Does an association have to allow renters? And if so, what's the minimum number you can allow?
You do not have to allow renters. And that would be something that is in the condominium documents. I believe that an association, as long as an amendment gets passed to prohibit renting at all, that I believe that that should be valid.
Could you reduce the percentage to 5%?
Yes, you can reduce the percentage to 5%. That I think that there might be some practical considerations about getting that amendment passed, but yeah, the rental cap of 5%, there's nothing wrong with that, as long as you can get it passed.
Thanks.
You're welcome.
We're good at getting things passed.
Okay, so moving on to some common exceptions to rental caps. If someone, if the co-owner of the unit dies, that could be a reason to allow that unit to be rented until the unit, could be sold. If there's a divorce or financial hardship where the co-owner needs to rent the unit to, I guess, pay their mortgage or pay their assessments. For medical purposes, such as moving, where a co-owner has to move into assisted living, then they would be allowed to rent their unit. Relocating for new employment, such as out of the state, or the great catch-all of any other extenuating situation approved by the board of directors. So these 6 exceptions, those can be included in any kind of amendment to prevent any what-if guy from voting against a rental cap, because those, if there is a rental under one of those 6 situations or any situation that are included in the proposed amendment, then those unit rentals would not count against the rental cap. Okay, so now let's move on to association remedies. All right, bylaw violation. The Renters Paradise Condominium Association shuts down party animal Pete's late night parties. Pete gets lonely and buys a dog named Trevor. The condominium bylaws do not allow pets. Since Pete does not have a written lease, he claims that he never agreed to abide by the condominium bylaws. Does Pete have to comply with the bylaws?
Yes.
What do we think?
Yes.
Couple yeses.
Yes.
Yes.
All right.
No,
Couple
I
more.
would think yes, certainly the the lessor would be subject to any sort of monthly penalty fee, which I assume he would pass on to party animal Pete.
That's a good thought. And before we go off this slide, I just want to say that that picture is my dog Trevor, and he is adorable, and I had to include him in this.
Look at
All right.
Trevor.
He's adorable. All right, let's get back to it. All right, so tenants or non-co-owner occupants shall comply with all of the conditions of the condominium documents of the condominium project, and all leases and rental agreements shall so state. So what does that mean? Tenants are required to comply with the bylaws. So the brain trust present here is 3 for 3 on hypothetical questions. Maybe this next one will stump you though. Okay, Renters Paradise Condominium Association has finally had enough of Pete. Pete has decided to keep Trevor and has resumed the late night parties. The association wants to take action against Pete. The board of directors discusses potential options. Paul, the president, states that they can only pursue Lucifer, the landlord, for a bylaw violation and impose fines since Pete is not a co-owner. Sam, the secretary, who lives next door to Pete, says that the association has to do more and evict Pete. What can the association do?
Go to the landlord.
Go to the landlord, pursue him for a bylaw violation?
Yeah.
Get the landlord to evict the tenant because of the persistent bylaws violations. The agreement has to have some sort of compulsion with the rules.
Mhm.
And we had one here in Pinewood Village that we got rid of a tenant that had been an issue. And the landlord was reluctant because they paid the rent on time. But they were evicted. I'm not sure if it's because we hammered the landlord to do the evicting or we actually did the evicting ourselves. It was before my arrival on the board.
Okay. So I think that's a good point of who can do the evicting. The chat says that the association can evict the tenant
Both.
and evict Pete and violate the landlord. Well, let's find out. So under MCL 559.2124 of the Condominium Act, the association must notify the co-owner by certified mail of an alleged violation by the tenant.
Mhm.
The co-owner then has 15 days after receipt of the notice to investigate and correct the alleged breach by the tenant
Mhm.
or advise that a violation has not occurred.
Mhm.
If after 15 days, the association believes that the alleged breach is not cured or may be repeated, it may institute an action for eviction against the tenant or occupant and simultaneously for money damages against the co-owner and tenant or non-co-owner occupant for breaching the condominium document.
Yep.
So this provision of the Condominium Act allows not only for the association to hold the co-owner in violation of the bylaws, but also to evict a tenant who has violated the bylaws and that the association believes either will not cure the violation or will repeat the violation.
How many times do the cops have to come out to establish the legally acceptable criteria for the eviction?
That is a good question. There is no number. I would say that the more evidence an association has, the better to establish that there has been a violation. However, you don't want to wait 5 times for the cops to come out just to have that evidence, because during those 5 times there could be damage to properties. You could have co-owners being annoyed. You could be losing money one way or the other. So
I was thinking at least 2. You don't have, in baseball, you only get 3 strikes. You don't get 5.
Right. I mean, again, I think there is no clear line as to how much evidence is sufficient. And under this portion of the statute, there does have to be notification of the violation to the co-owner and an opportunity for the co-owner to investigate and correct it. So we have a question from the chat. How does an association address a tenant who may be growing marijuana in the unit? So marijuana is a tricky situation. but the path that the association should take is consistent with this provision of the Condominium Act of notifying the co-owner, allowing a chance to investigate and correct, and if not, then pursue an action for eviction of the tenant and for money damages that may be incurred as well.
Well, I believe Michigan law now allows you to grow your own for, medicinal or personal recreational purposes. Are we talking about if they're turning their unit into a grow house?
Well,
that's a great question, and again, that just depends on the facts of the situation. If someone is complying with state law, it might be difficult to get them evicted. However, marijuana is still illegal under federal law.
yeah.
So there is some tension in there between state and federal law.
So if we're going to evict someone on that, we would have to cite getting on the bad side of the Fair Housing Act?
Well, the Fair Housing Act only applies in situations where there's a reasonable accommodation because of a disability. So if it is medical marijuana, then that could be a basis for a reasonable accommodation where the co-owner is allowed to have marijuana. But again, that's just going to be a fact-specific inquiry. And then let's see, some questions from the chat. So should the association request to enter the unit? We are advised that private communities are not bound by state law, and I'll follow up to that as well. Condos can follow federal law rather than state. So yeah, those are two really good points. And then sticking on marijuana, I thought medical was for personal use, not growing it commercially. Yeah, that's also a good point. And again, that just goes back to the fact specific. Is this kind of one plant that's being grown just for somebody to use because of a disability that they have under the FHA? Or is this a situation where somebody has a commercial marijuana grow operation where they have hundreds of plants all around, and this is their business? It's just really going to depend on the facts of the case.
Follow up. If you have a co-owner that has black plastic hung in a window to try to camouflage the grow light, is that enough? Is that enough suspicion to request entry into that unit for inspection?
I think that would depend on your documents as to what allows the association to go into someone's unit. If your documents don't allow for entry to investigate a violation, then I don't think that would entitle the association to go into the unit. Typically, we see entry into unit relative to replacing or repairing a limited common element. And so unless there is some issue in that situation, unless there's some issue that needs to be repaired, I'm not quite sure whether a bylaw violation in and of itself would allow entry into a unit or an allegation of a bylaw violation. And then sticking on the marijuana issue from the chat, if someone has a grow operation, isn't that commercial use of a residence? Again, it depends. Just like what Timothy says, depends on the number of plants, depends on the facts of this situation. Can a co-owner be required to investigate a rental unit? So Kay Lloyd, do you mean if in the context of a bylaw violation, can the co-owner be required to investigate the unit?
Yes.
Yeah, so under this portion of the statute that's on the screen right now, if a renter hypothetically has a grow operation in their unit where such activity would be prohibited under the bylaws, then the co-owner should be notified and would have a chance to investigate that violation. And so whether the co-owner can go into the rental unit, I think just would most likely depend on the terms of the rental agreement. But that's a good question. All right, so now we're going to move on to our next hypothetical. So we go back to Lucifer. Lucifer, the landlord, is unhappy that party animal Pete has been evicted. Lucifer withholds his assessment payments until he can find a new tenant. Lucifer enters into a written lease with Follow the Rules Francine to rent the unit for $1,000 per month. Lucifer owes the association $5,000 in unpaid assessments. The association calls Francine and tells her to make all future rental payments to the association to satisfy the delinquency. Lucifer tells Francine to pay him the rent because she was not a tenant when the delinquency arose. Who should Francine pay?
The association.
One vote for the association, 2 votes for the association from the chat.
The agreement was with the renter or the person who owned it. That's where it goes.
Well, let's find out. So under the Condominium Act, the association may give written notice of their arrearage to a tenant occupying a unit under a lease or rental agreement. After receiving notice, the tenant must deduct the arrearage from the rental payments and make the rental payments to the association to apply to the delinquency. If the association does not cooperate, the association may issue a statutory notice to quit for non-payment of rent to the tenant and shall have the right to enforce that notice by summary proceeding or initiate proceedings pursuant to MCL 559.2124, which we discussed about 2 slides ago. So in this situation where Lucifer owes $5,000 in unpaid assessments, the association has to give notice of his deficiency to Francine, who would then make her monthly rental payments to the association directly instead of paying it to Lucifer. All right, and with that, we have reached the end of the presentation. So if anyone has any questions, I'd be happy to do my best to answer them.